Hello and welcome to this program of School of Law. Today's topic is meaning and sources of international humanitarian law. And in today's program, I will talk about the basics of international humanitarian law, what is its meaning, and where we can find it. So it is a this session is related to our certificate program in International Humanitarian Law, CIHL. The course code is PLE 35. And this course talks about the international humanitarian law, its concepts, the treaties and conventions, and its application in South Asia. So, when we talk about international humanitarian law, first we should understand that it is mainly a part of international law, and it was developed. If you trace the development of humanitarian law, it was started to develop in 14th, 15th century in Europe, and major development took place in 1899 and 1907 when a number of Hague Conventions came into existence, and thereafter we see that there are a number of treaties. The purpose of international humanitarian law, as you can see on the slide, is to limit the use of force, and weapons. Ideal situation would be that the states need not have recourse to war. But we know the reality. Armed conflicts continue to take place even today. Our United Nations was established in 1945, and its purpose was to limit the armed conflict, and the objective of the United Nations was to settle the international disputes by peaceful means, and it is reflected in Article 2 of the Convention, various subclauses of Article 2, which says that the state shall settle their disputes by peaceful means, and in exceptional circumstances forces will be used. But this is the ideal situation. The international humanitarian law tries to limit the use of, suppose we can say that it limit the use of force in the context of civilian people, because civilian people are not directly participating in war, and it also limits the use of force, bacterial weapons, nuclear weapons, and biological weapons, and people who are not directly participating in the armed conflict should not be subjected to any kind of torture or any kind of attack, because suppose a prisoner of war, a person who has been captivated, is not directly participating in the hostilities. uh, and the non other non-combatants such as medical personals, uh, people who provide logistics, food, ration, transport services, etc. These people are not directly participating in the hostilities. So these people should not be subjected to any kind of attack or any kind of maltreatment. Uh, so uh, when we talk about the application of IHL, as is clear from the discussion so far, that it mainly, because it's a branch of international law, so it mainly applicable in case of armed conflicts between two states or between groups of states. But recent developments, especially developments in 20th century, has shown that the principles of international humanitarian law should be applied in what we say a non-international armed conflict, a conflict where a resistance group is fighting against the established government. Any armed conflict is not covered under international law. Suppose there is a public order problem, or some civilian people are fighting against, they are agitating, or they are running a movement, civilian movement for their rights, or for their some demands, or for against the atrocities. So every kind of resistance against the state is not covered, but the condition is that it should be an armed rebellion, and there is an organized kind of force, and the magnitude of the conflict is such that it cannot be covered, or it cannot be handled by normal law and order machinery. Suppose a rebellion group is fighting to overthrow the government, or armed resistance group is fighting for secession of some part from the state, or there can be a number of situations. So international humanitarian law is applicable in armed conflict between the states, as well as the armed conflict between the state and organized resistance group. So actually international law, and especially the international international humanitarian law, was developed through customs, and now it has been codified in a number of conventions, and even today customs play a role in developing the law in those areas which are not covered by any treaties or conventions. So there are mainly 4 conventions. First convention is mainly related to the land warfare. In 1949, 4 conventions were adopted, what we call the Geneva Conventions. And after the Second World War, it was felt that there should be a binding international instruments to compel the states to adhere to at least some minimum standards of protection of those people and places which are not participating in war-like situation or armed conflict. So the first convention was a Geneva Convention, which is related to land warfare, and the second convention is related to the warfare in the sea. Both these conventions contains almost analogous provisions. These conventions mainly deal with the situations where the armed forces can be used or the weapons can be used, and the main purpose of these conventions is to regulate the use of force or use of weapons in whether it is land warfare or the warfare in the sea, armed conflict in the sea. So the kinds of weapons which can be used, the weapons should not be excessively harmful. And the effect of weapons should not be beyond the area where the conflict is taking place. Weapons of mass destruction should not be used. Bacterial and biological weapons should not be used. And the civilian places, temples, monuments, schools, hospitals, etc., these should be protected. And the third convention is mainly related to the prisoners of war. Prisoners of war who are held captive by the warring parties, they are not liable to disclose any information except their rank, their badge, etc. They should not be subjected to any kind of torture. They should be treated humanly in the captivity. And they should not be subjected to forced labor. However, some kind of work can be taken from them, but it should not be very it should not be harmful to their health and their physical well-being. And their conditions where they live should be humane. They should be provided basic amenities, food, clothing, etc. And their medical needs to be taken care of. They should not be left unattended. And when the armed conflict ends, it is the duty of the parties to release them as soon as possible. Another convention is related to the civilian population. This is called Convention 7, no, 4th Convention, Geneva Convention. Civilian populations, people who are not directly participating in the war, people who are doing some business, teaching in schools and colleges, students, medical personnel, and any civilian population who are not directly taking place, because armed conflict generally takes place between the militaries of different parties, their armed groups, and the civilian population residing in those areas are not directly involved they may support these people more emotionally or morally, because without their support, armed rebellion cannot continue for a long time. But at the same time, they are not directly participating. And there may be situations where one party has occupied the territory of another party, another country. In that case also, the civilian population who is under occupation, since they are not directly participating in the conflict, their rights should be respected. Their laws, their customs, their religious values, their religious beliefs, their monuments, things of civilian importance should be protected. And there are two Geneva Conventions, two protocols of 1977, which because it was felt that some modification or some addition is needed in the fourth Geneva Convention. So two protocols came into existence in 1977. One is related to non-international armed conflict. This enhances the protection. These protocols interpret the provisions of the conventions in the line of the current, in the prevailing situations, and provide some more protections. And there are other treaties and conventions which you can see on the slide. Bacterial weapons related to biological weapons, bacterial weapons, asphyxiating gases. So these are some of the important conventions which mainly cover those aspects which I have talked about, which have been covered in 4 Geneva Conventions and 2 protocols, and also in 1999 and 1907 Geneva Protocols. These are covered in these. These are some expansions. I mean, the other conventions which you have seen on the slides are mainly, you can say, expansion of the provisions of 4 Geneva Conventions protocols, and they cover different aspects of the armed conflicts. So with this we wind up our today's presentation. Thank you very much.